Hey, good morning, everybody. Law and Legitimacy, welcome back. It's Friday, the last Friday in July 2023. Make it a good one. People are lining up to say good morning already. Good morning, Matt Kyle. Good morning, Pat Clifton and the other angry dog. Good morning, Luttrell. A dismal third today, but we appreciate the effort because it still came in promptly at 8 o'clock.
Bronze-medal effort from Luttrell this morning. Good Lord.
The early bird, it is said, catches the worm. It also catches law and legitimacy. Lots to talk about today. We want to talk, because one of our themes this month is welcoming newbie lawyers, law students to the profession. We're trying to spend a little more time than usual talking about the nuts and bolts of law, about the mechanics of what it is that lawyers do, and trying to make it possible for law students not to be overwhelmed by all the flotsam and jetsam that'll be thrown their way in their law schools, and to walk away with what's really necessary. And here is memo number 2, or 3, or 4, or whatever the case may be. Do your own research. Check your citations. What am I talking about? We talked the other day about the case law method of learning law. You know, the dean of the Harvard Law School, Dean Langdell's method of teaching law was to bring students up to speed about the current status of the law, those rules that govern relationships between strangers and create stable expectations in a society. We talked about those being developed in cases by parties who have actual interests in conflict, and judges having to decide cases under the rule of law. And so what that means is that to master a given area of the law means to understand reported decisions on common issues that occur in that area. And so when a decision becomes very influential and a lot of judges rely on it, it might develop standing of its own, and it might shed light on what's called a doctrine or a legal theory, a way of understanding the relationship between isolated facts. And so reported cases become important because they become precedential. In other words, they say to one judge, look, this is what your colleagues have said. And in the case of a legal doctrine, it is well settled law that over the decades and or centuries, judges faced with a fact pattern, that is a set of circumstances that looks similar to the one you're seeing, have decided the case in thus and such a manner. And the key skill of a lawyer, quite frankly, is research. I remember in undergraduate, lots of people talking about going to law school. And I remember one kid saying, yeah, I hate writing. I'm going to go to law school. And I'm thinking,
what a joke.
Yeah. And I said, no, how's that going to work? He says, you argue all the time. You don't have to write. Writing is for idiots. And I'm like, you can't argue if you can't write, and you can't write if you can't research. And thus, one of the primary courses, perhaps the most important course you take in your first year in law school, is legal research and writing. And that means you learn how to find cases, you learn how to use indices, you learn the citations, that, in other words, the notations that make it possible to find cases, and you become accustomed to reliable databases that have been vetted by other legal scholars and are reliable. Things like Westlaw, Bloomberg Law, LexisNexis. I mean, sure, it's a market, it's a competitive market, and they're going to give you these vendors free access to their product while you're in law school, so that you get so addicted and accustomed and reliant on their product that when it comes time to charge you, you'll pay handsomely for the privilege of access to their database. But candidly, it's worth it. And it's what you need to do to learn your craft. It's what you need to do to advise your clients. It's what you need to do to advance your litigation in courts of law. But what they don't teach you in law school is that the law is a business. While it's a profession, there are also costs and benefits, and there are marginal costs and benefits. And every case is going to place you as a practitioner in a position of having to evaluate the benefits of each additional increment spent on a case. In other words, you could fight every issue to the absolute death and go broke doing so. You have to select the issues that are important to your client, and you have to marshal your resources effectively so that you can keep your shingle up, pay your bills, and advance your client's cases. AI increasingly seems to be offering lawyers a way out of the cost-benefit analysis. And we have another very, very disturbing report from the 10th Circuit Court of Appeals in Texas this morning. Mike found it. I think it was it in Reason magazine?
It's the 10th District Texas Court of Appeals. And yeah, this is through the Volokh conspiracy by way of Reason. But I found this because this actually makes reference. What's interesting about this court opinion, and I think you probably caught this, Norm, is that the court in this actually references the prior case that we talked about with respect
to the Mata case in New York, yes. Right? Yeah.
It actually makes specific reference to that case. And this was an appeal from a criminal conviction for a count of aggravated sexual assault, 2 counts of sexual assault. And
no, Mike, you got something wrong. I don't mean to be abrupt. This was an appeal from a denial of bond. The man had not been convicted yesterday, and it becomes significant in the cost-benefit context. In a minute, please go on.
Yes. So I meant to say the defendant in the case had been convicted of those 3 counts.
Charged.
It's being sent back down.
Here's how I read the case. And this is a good example, folks, of why law school is collaborative and why it's a collegial enterprise. As I read the facts of the case, this is a man who was held on bond in lieu of trial, in lieu of his charges, and he sought to make bail and couldn't. And so he sought a bail review application by way of a habeas corpus, saying that his a petition that says you unlawfully have my body and I'm entitled to make a reasonable bail. This was prior to his trial. This is while the charges were pending. And so he was denied bail, and his lawyers took what's called an interlocutory appeal, an appeal prior to a final judgment, in an effort to get a reasonable bond for him. And so they had to persuade the appellate court that the district court erred in the manner in which it arrived at bond. And what they did was shocking. Mike, tell everybody what they did.
Well, what they did is they denied bond and ultimately addressed the issue of the argument section in the brief that the defendant's counsel had put before the court. And what they argued was that the lower court had erred in setting the bond amount too high. And they gave the applicable standard of review for the case, which is... And
a standard of review is important in any appellate procedure. Basically, you're telling the court what you want it to do and how it's supposed to do that. So the standard of review might be abuse of discretion. In other words, the court had the right to make a decision, but used its discretion in a way that is unlawful. You could make a claim that they made clearly erroneous factual findings. It could be what's called de novo review. You don't have to look at the court's factual findings, but the appellate court itself can make its own determination of the facts. Finding the standard of review is the task of appellate lawyering, and you'll spend a lot of time in law school on that. Standard of review is typically not controversial because there have been so many cases of a given type. People know where to look. And so lawyers sometimes insert cases in their briefs that are called boilerplate cases. In other words, the standard of review is so well known, you can cut and paste standard of review from one brief to another safely. And as you become a practitioner, you'll have your own boilerplate language that you'll rely on. But beyond that, then there was argument.
As a quick aside, this was sort of the narrow issue in the case that we discussed yesterday of the Hunter Biden plea agreement. The judge was asking the attorneys for Hunter Biden how she was supposed to weigh in on the plea agreement before her and under which criminal statute they were pursuing. So that's just a quick aside, is to say that it's imperative that the judge is able to coalesce around the review standard for a given set of law, because otherwise they could make an erroneous judgment, right? So in this case, they've put, in a like you said, Norm, in the criminal context, this is probably more of a garden variety appeal that these defense attorneys have made, seeking a reduction of the bond. This may not be that important of a procedural aspect of the case. They're just attempting to get their client out of jail pending the outcome of the criminal case. And for that reason, right, you posited to me before we got on the stream that this was something of a routine, whatever. And really, there wasn't a whole lot of thought that went into this. But here's the interesting part. I'm going to read it for the audio only, but if you're watching, you can see what I have highlighted on the screen. However, in his argument section, where appropriate citations must be included, Lee cites to 5 cases to sub-arguments to his issue. Only 3 of those 5 cases are published. None of the 3 published cases cited actually exist in the Southwest Reporter, which, for those of you that are unfamiliar, the Southwest Reporter is just one of many regional places where published cases are bound together, which Norm talked about research engines for LexisNexis and stuff like that. They will aggregate all of the case reporters for attorneys to be able to reference cases and precedent and identify issues for fact patterns that they themselves are trying to work through in a different court. Going on, each citation provides the reader a jump site into the body of a different case that has nothing to do with the propositions cited by Lee. 2 of the citations take the reader to cases from Missouri. As the state points out, even Texas cases with the same names as those cited by Lee do not correspond with the propositions relied upon. And so then the court goes on to say that, let's see, is it right here? To avoid this problem, Federal District Court Judge Brantley Starr requires the following certifications for pleadings filed in cases pending in his court. And this is what pulls up when you go there, Norm. It's actually a certification regarding generative AI intelligence that a judge in Texas now requires all attorneys to file with every single court filing before him on the docket.
Yeah,
right?
so let's talk about that a little bit. I want to unpack some of the things that Mike said, and I want to talk to you about practical aspects of the law. You're now a practicing lawyer. You've hung your shingle up in every town, and somebody comes to see you, and he's been charged with serious crimes, and his bond has been placed very high, and he wants to know what you can do for him. Well, what you tell him is, I can defend. I can research the law, hold the state to its burden of proof, try to negotiate the best possible deal for you. If we can't negotiate a deal to your satisfaction, the case will almost certainly go to trial, and I will do my best to defeat the state's case at trial. And for that, you typically charge a fee, and it's usually a lump sum fee in the criminal cases, in the criminal context. Very few people can afford hourly fees, individual clients. So you've now taken $10,000, $20,000, $30,000 to defend this man against very serious charges, and the bond is set too high. And so he demands an appeal of the bond. Well, he has a right to take that appeal of that bond determination, but now you're working at a, every additional brief you write reduces your margin of profitability on the case and makes it more expensive to engage in the next activity. So is this an activity that you put at the very top of your list of your priorities, or is it near the bottom? The client's liberty interest is near the top of his list. And from the lawyer's perspective, what's important is a successful resolution of the case, whether the client is in or out. So these lawyers almost certainly split the baby and decided to satisfy the client by shorting him on the research.
Which is unreal, Norm.
And it has all the hallmarks, this decision, of what happened in the Mata decision, where they probably used a generative AI device, asked it a question, and then the AI device wrote an answer, and they submitted the answer to the court. But the shocking thing is, even when the state pointed out, their adversary in this proceeding, the shortcomings in the brief, they did nothing. They didn't file a reply brief. They didn't double down and try to justify it. They didn't apologize as the lawyers did in Mata. They simply ignored it. And so the Texas court gave them a pass and said, because the issue was not adequately briefed, you've given us nothing to decide. And
I have highlighted here looking for before, and I apologize for dropping the ball there, but the court says literally, it appears that argument portion of the brief may have been prepared by artificial intelligence. That's a direct quote from the opinion, from the order. And then they go on to say, like you said, because we have no information regarding why the briefing is illogical, and because we have addressed the issue raised on appeal, we resist the temptation to issue a show cause order as a New York federal district judge did in Mata v. Avianca, which is the one we were just talking about. Thus, Lee inadequately briefs his sole issue on appeal. The failure to adequately brief an issue presents nothing for us to review, and we are not required to make an appellant's argument for him. Accordingly, because Lee inadequately briefs his sole issue, it presents nothing for our review and is overruled. But there's nothing about disciplining disciplining the attorneys that put that before the court, which is my main issue here. We talk a lot about the requirements of candor toward the tribunal. You talk about the need to be able to research and write well. But it's amazing to me that the court stopped at saying, well, we don't really have anything here to. It appears that this has been prepared by artificial intelligence, and as such is perpetuating a fraud on this court and the other party to the proceeding, right? The state of Texas. And we have no issue with that.
So it makes you wonder what's going on out there. And when we talked about this prior to the show, Mike, I said, I just wonder if it's fatigue. And let me give you a perfect example. This week, I had a shocking experience. My local bank changed its telecommunications access to accounts. And it was shut down over the weekend. And when you called in, you got a new menu that you had to navigate. And of course, I couldn't navigate it. So I fought my way through the if you want X, press 1. If you want 2, press, 2, something else, press 2. I finally get to an individual. And the individual has a distinct Indian accent. And now I have to spell my name 3 times, and they still don't get it right on the 3rd occasion. I asked to speak to a supervisor, and the supervisor is clearly reading from a script. I asked to speak to somebody at the branch itself, and I'm told, well, I am at the branch with an accent that I don't recognize as the New England accent. I say, are you actually at the branch? I'm sorry, the connection has gone bad. No, the connection hasn't gone bad. You can hear me. Are you in New Haven? You just told me you were. I can't hear you. So I hung up. But and now I'm left with a dilemma. Do I change banks because my bank has decided to cut costs and go international in its own cost-saving method? And the result is I'm now going to get less customer service by people who don't know me? Or do I bow to the inevitable and realize that in the new age of globalism, poor service is the new global norm, and we're all equally miserable, and thus equity has been achieved? And I'm debating that. And I can see from the federal appellate court judge's perspective a similar fatigue. We know that AI is making inroads into legal research, and we know that there's going to be a lot of garbage generated. And here's another piece of it. It's almost like the court is signaling it's too much work to try to put their finger in the dike that is bursting with all of this faulty information. And Mike, I accept your outrage over this, and I think you're right. There should be further inquiries. I mean, I suspect that, the new certification requirement that a lawyer certified that they did their own research, or in the alternative, at least check the citations that AI generated for them, is important. Because when you certify a document in court, you're putting your name behind it, and you're saying, I am telling you, the court, the following is true about this document. I researched it. I vetted it. I double checked the sites. And this is work that if I didn't do, I am at least endorsing. And sadly, we've come to the point where that's necessary. But the Texas appellate court seems to be showing signs of what I'll call globalism fatigue. As big data takes over increasing areas of our life, and as the race to the bottom goes full-fledged forward in the effort to save costs and to reduce service and to reduce transactional costs to the absolute minimum, these lawyers in Texas apparently succumbed. And they used a device to substitute for their own judgment at the margins of a case, got caught, and the appellate court was too tired to do anything about it. That's scary.
Yeah, and I want to read the last paragraph of the certificate that Judge Brantley Starr out of the Northern District of Texas requires for all of the filings in front of it. It talks about, the need to attest to the fact that, nothing was produced that was a result of ChatGPT, Harvey AI, or Google Bard, or that if anything was, that it was actually checked for accuracy using print reporters or traditional legal databases, as we talked about a few minutes ago, by a human being. And the last part of this says, and this is, I guess I don't understand how the ABA hasn't done anything on this issue yet. I certainly don't understand how Rule 11 hasn't been interpreted to include this sort of conduct. I also don't know why attorneys need to be told not to do this stuff. I think that's really where it's losing me, is that there are attorneys willing to simply to have stuff made up and put their name on it, sign it and put their name on it, and would disrespect the institution of the court to that extent. But I'll just read this and I'll get off my high horse here. Accordingly, the court will strike any filing from an attorney who fails to file a certificate on the docket attesting that the attorney has read the court's judge-specific requirements and understands that he or she will be held responsible under Rule 11 for the any filing that he or she signs and submits to the court, regardless of whether generative artificial intelligence drafted any portion of that filing.
So Rule 11, folks, is a rule that sanctions or that raises the potential for sanctioning a lawyer who acts in bad faith, and typically requires a party moving for sanctions under Rule 11 to give somebody a 21-day period to correct their failing, the so-called safe harbor provision, on the theory that we don't want to encourage lawyers to go to battle with one another over the nominal professional requirements of the trade, or judges either. So it's and so I think this judge, I don't like having idiosyncratic filing requirements by differing judges. It's hard enough to follow all the rules and to get the law right and to satisfy your client and deal with your adversaries. But when each chambers has its own chambers practice, you start feeling like that guy in early modern Europe trying to take his produce down the Rhine, and every 100 meters there was a different overlord to pay, to have a tax to go by. And the result was that by the time products traveled 60 miles down a river, they'd become so prohibitively expensive no one could afford to buy them. Individual idiosyncratic filing requirements increase the cost to lawyers of complying with court rules, and those costs are either going to be transferred down to their clients, or they're going to be absorbed by the lawyer in the form of the kind of chicanery that we've seen in the Texas case. So Mike says, where's the ABA been on this? The American Bar Association has has bodies, entities that set standards that it encourages others to adopt, other states to adopt, these states to adopt. There's also something called the American Law Institute, which studies problems emerging in the law and publishes things called restatements or statements of the law. These have great persuasive authority around the country. My hunch, Mike, is that AI is happening quicker than the law can accommodate. And as we see these cases being reported now just this year, it's going to take 3-4 years for the ABA to catch up.
This isn't something that should take very long.
It will.
Seriously, it blows my mind that there would be some sort of bureaucratic slowness to addressing this issue. And my perspective is, from the ground up, it should just be attorneys such as you, Norm, adding your own custom certificate to every single filing that says something substantially the same as what this judge in Texas has argued. It's just a practice that you arbitrage, right?
That's a great idea. And, that's
it's,
a great idea.
You just add to the back of the filing the same as a certificate of service, acknowledging that everything's been served, that you've made sure that the defendant, their agents, whatever, have gotten notice according to the rules. You just have an additional certificate of service saying that everything contained in this was done by a human.
Or at least reviewed by a human, if it wasn't.
Which is ridiculous.
It's ridiculous, but it's the world we now live in. I mean, again, let's go to the customer service thing. And you get on the phone, you're speaking to a voice that's recorded and been pre-programmed to respond algorithmically to things. And whether they're doing so correctly or not, you don't know. And when you want to speak to a person, they're consulting another manual. People are afraid of intimate contact and the work it takes to actually communicate. And the result is we're relying on third-party devices to handle increasingly large aspects of our life in ways that don't satisfy and in ways that can mislead. This is an example of it.
Let's talk about other ridiculous stuff.
Well, yeah, let's pivot to Trump, because we're running short on time, and there's been a lot going on in Trump world. I mean, Harbaugh. Okay, well, you got Harbaugh's up there. My hero, Jim Harbaugh, 13-1 last year. Of course, he didn't get it done in the national championship. Got beat by the Texas Christian Longhorns, or what are they? Green? What are they again? I can't even remember.
Texas Christian Horned Frogs.
Yeah, something like that, some ungainly name. But Harbaugh's been suspended for 4 games, or is likely to be suspended for 4 games. Negotiations are underway with the NCAA. There are apparently recruiting violations and apparently on-the-field violations where non-coaching staff were permitted on the field, coordinators or scouts and whatnot. And
it's a series of ridiculous stuff dating back to COVID, right? There's allegations of too many coaches participating in the stuff, and these are all the level 2 stuff. The level 1 thing is where Harbaugh took a couple of players to like a fast food joint, and there was a receipt, and then the NCAA is scrutinizing him because he wasn't totally truthful, or he misled them as to the nature of the meeting. But then it's, him texting recruits, him also having a Zoom video review of on-field practices. That's part of the problem, right? I mean, I think what Matthew Kyle would say here is that it's a sign of a good coach. And so I'll give you some flowers here as a Michigan football fan, Norm, is that I would love to have a coach that is finding every available opportunity during a really consequential period in our recent sports history, which is trying to maintain some sense of stability and discipline with young people when the rest of society has said, don't be with one another, don't talk to one another, all of this kind of weird stuff. He's finding and innovating in real time, saying, okay, well, if we can't physically be present and they're, then let's set up cameras. Right.
Yeah, I don't know what to make of the NCAA governance procedure. I mean, at the same time that we're now experimenting with name, image, and likeness, we're going to suspend a coach because he took some kids to a Burger King and wasn't candid about it. I understand the candor requirement, and shame on Harbaugh if he deliberately misled people. But a 4-game suspension for treating his kids like human beings and showing that he cares seems a bit rich. And I think the NCAA, I don't know what it's up to in this case. And of course, I have no objectivity in this. I mean, my
girl says, if you ain't cheating, you ain't a Wolverine.
So T-Girl just won herself a 1-week banishment from public comment.
I guess that's the type to say "the" before something they think is important, right?
Yeah, the Iowa State University, or is it Nebraska? I don't know. It's some other state that in flyover country. So I got to eat a little crow today. I predicted last night on X that Donald Trump would announce on Truth Social last night that he's going to turn himself in on J6 charges, because, and the reason for that is I'd spoken to a reporter in the building yesterday at the Prettyman Courthouse in D.C. who reported that Trump's lawyers were in early to meet with D.C. prosecutors. The typical playbook has been, when shortly after a meeting, there's an announcement by Trump on social media, whatever confidentiality agreements may have obtained between the lawyers, they don't obtain between the Donald Trump and the United States government, that's for sure. And so I expected Trump to be on social media saying, I'm going to turn myself in next week on J6 charges, and I all but predicted the timing. Didn't happen last night. But what did happen yesterday is that Trump got charged with additional charges out of the Mar-a-Lago incident. And this is in the form of a superseding indictment. That indictment adds to his charge in Mar-a-Lago that is set for trial in May, a new defendant, another household staff member of his, and new charges. That is, that Trump and company made efforts to hide, eliminate, or otherwise deceive the government about the existence of videotapes that may have shed light on the failure to turn over classified information. The significance of this is easy to overstate. It's Donald Trump, so something's happened, and of course it's going to be front page news. Superseding indictments are not uncommon in criminal cases, especially criminal cases that involve an ongoing investigation. As federal authorities come to learn of more potentially criminal conduct, they'll add defendants and add charges. What is significant is the judge had set a May trial date for the Mar-a-Lago cases, and it's almost certain that the addition of new charges and a new defendant will result in delay of that trial. I would be stunned if the trial takes place now in May. And if it doesn't take place in May and Trump does become the Republican nominee, I suspect it won't take place until after the general election. So stay tuned on that. It wouldn't surprise me to see even more superseding indictments out of Mar-a-Lago and additional people added to the mix. But this is I think the third superseding indictment in that case. There are now 3 defendants, a total of 40-some charges. And the new charges, whether they can be proven or not, they sound in manipulation, destruction of evidence, and a lack of candor with response to federal investigators. You are under no obligation to speak to a federal investigator. You have a Fifth Amendment right to assert the right to remain silent, to avoid incriminating yourself. There's also something called the act of production privilege. If the government asks you to produce any and all documents relating to transaction X, you can refuse to produce those documents under the so-called act of production privilege, which is closely related to the Fifth Amendment privilege. You're requiring me to evaluate, as I turn these documents over, which ones may or may not be involved or related to the inquiry you're asking me about. That act of production on my part is testimonial in character, because what it does is it evolves or engages my analysis of the data, providing you with information about what I think. And so producing documents can be in response to a general request, can be every bit as revealing as answering questions about a general request. So if you're approached by the feds and they're asking questions, get a lawyer, assert the Fifth. If you're approached by the feds and they're asking for documents, get a lawyer and have that lawyer evaluate whether you need to turn anything over. In this case, it wouldn't surprise me if Trump and others, as alleged, got together and had discussions about what they could do to avoid complying with the federal response. It's going to get you in trouble almost every time.
Well, they definitely, the investigators have definitely flipped an employee. I think it's employee 4 that's referenced here on the screen, but I went through those several things, and they're, to my knowledge, based on the allegations they made about the attempt to conceal or the attempt to destroy video footage, there was no direct evidence. This was all testimony of the employee recounting timelines of who talked to whom, when, what text messages were sent between what employees, when, certain travel plans, and then a reference to the boss, right?
Yeah.
So I don't know. This was certainly a plot twist from my perspective. I'm with you. I'll eat crow here as well. You and I both thought that the J6 stuff was next on the docket. I didn't expect that Jack Smith and company would add additional charges and an additional defendant in Carlos de Oliveira. As you see his name there on the screen, Nada was there from the beginning, but it does appear, at least on the count of attempting to, because that's what's leading, is like the video evidence. If one simply reads the superseding indictment and reads the allegations of fact as they're in here, certainly there is opportunity, and certainly it's easy to believe that narrative. And I think, as you just said, one can assume that maybe there were conversations about, what can we preclude, them from getting, or what can we withhold. But it's a big stretch between the allegations of, concealing or attempting to conceal, which is,
well. So let's talk about the law of attempts, because some people, a crime is when you engage in conduct that the law prohibits. And so two elements of every crime are a mental state, or it's of some sort, and then the prohibited act, the so-called mens reis, what's in your head, the actus reus, what you did. And so you can have the intent to commit a crime and discuss with others the commission of that crime, but you might fail for some reason to actually commit the crime. In that case, you're not guilty of committing the crime itself. You had the intent to commit it, you tried, but you failed. The question is, do you get the benefit of failure? The law of attempt says, no, you're still culpable if acting under circumstances as you believe them to be, you took steps to avoid what the law requires or to break the law. And if you failed, you're every bit as culpable under the law of attempt as if you had succeeded in performing the prohibited act. It's closely related to the concept of conspiracy. A conspiracy is an agreement between two or more people to violate the law, and the crime is not actually violating the law. The crime is the agreement to violate the law, and so these so-called inchoate offenses that don't mature into completed crimes, are troubling aspects of the criminal law, and they spread a very broad liability net. And so I'm less optimistic than you are, Mike, or less sanguine than you are, Mike, about the fact that no document was actually, they don't have actual proof that something was destroyed. The effort to do so, the discussions about doing so, preparing to do so, acting as though it would be done under circumstances as they believe them to be, all of that's going to get them in trouble under the law of attempt, every bit as much as if they destroyed the document itself.
Right. And so that, but I think that that's what I'm leaning into, is that there isn't a, here it is on the screen. Donald J. Trump, Waltine Nauta, and Carlos de Oliveira did corruptly alter, destroy, mutilate, and conceal a record, document, and other object, and attempted to do so with the intent to impair the object's integrity and availability for use in an official proceeding. So that's the actual text of what the count is. And so they specify that is Trump, Nauta, and de Oliveira requested that Trump employee 4, which is who I said rolled, delete security camera footage at the Mar-a-Lago club to prevent the footage from being provided to a federal grand jury. So the action here is requested.
Yeah, and that'll get you. And this person is referred to
right
in the indictment as employee 4. I think it was an independent contractor, maybe a caterer. I may be wrong about that. But I think it's just, an attempt is as bad as completion. And so let's see what the evidence is. But I think the consequence of adding Mr. de Oliveira to the indictment or to the case is certainly going to cause delay. And this case will not go to trial in May. It's almost positive. I'm almost certain of that.
Well, so is that more of what we should take from this, Norm, from your perspective? Is that, I think all of us are concerned about the election question and his availability to be on the ballot, or what attempts will be made to preclude him from being on the ballot in November of 24. We've talked before, the need for a speedy trial, the right to a speedy trial. And you have, absolutely admonished Trump to step on the gas, so to speak, right? To go on offense and to get this stuff done, to dig in and to get this stuff done. And this is absolutely a wrench in those gears, right?
Yeah, possibly. And so is it possible that Smith said, we really don't want to go to trial right away. Let's keep this stick hanging over Trump's head. How can we do that? Well, let's add a defendant or two. Let's massage the evidence and find an attempt charge and bring somebody else in and let his lawyer ask for the continuance. What's the judge going to say? That's possible. I don't really know what goes on in the rarefied environment of special counsel's office, but that would be one set of calculations. More likely, I think attention has turned to January 6th. And I still think an indictment is forthcoming. I expected it to take place last month, and here we are in July, almost in August. I still say Trump is indicted before the end of the summer. Well, I would now say Trump will be indicted before the end of the summer on substantial J6 charges. And then the ball will be in Trump's court. And if he really thinks he's going to be president, if he really thinks he's a victim, if he really thinks he's being singled out as a result of venal prosecutors trying to keep him off the ballot, then he should transform the criminal prosecution into a campaign event and get it on now and get it on hard and fast.
Absolutely. I agree. I don't disagree with that one bit. I would just wanted to point out this great name we have here. You're my hero.
Yeah.
To you guys for months. Have a good weekend. Thank you. You're my hero. But that is
it's you're my gyro.
Well, it depends on how you pronounce it, right? You're my hero.
All right. All right. Got it. All
right. Love the name. Creative. But in general, we've had great attendance this week and activity in the chat. I want to shout out In the Cloud for the $5 tip over on Rumble. In the Cloud says, cheers to making it through another week, my fellow LALians. Yeah, we had some UFO talk this week as well. So thank you first and foremost for that $5 tip. We always appreciate that and do not ask, we don't require that of anybody, but we love the generosity and love bringing you what we can discuss every day. I think one thing that we didn't get to today was Kevin Spacey. I don't know that we'll get back to it next week, but at least worth acknowledging that sort of I view this as sort of an odd merger of fiction and reality, since he is responsible for House of Cards. And I guess the only thing I'd like to say about it is that my law school experience wasn't defined by House of Cards, but it was in the House of Cards era, right? As new seasons were being published, I was, in law school 1L, 2L, 3L year. And the plot of House of Cards, Norm, if you've never seen it, I assume you haven't, is no different than the reality through which we live right now with the Biden administration and the allegations of a corrupt DOJ, people going missing, geopolitical tensions, deals being made. Kevin Spacey's responsible, in my opinion, for House of Cards not being limited to Netflix. I'd like to get back to that point where House of Cards was only on Netflix. Instead, he gets charged in the Me Too movement, and we're just having to live it in real life, right? So, Kevin,
I'm aware of House of Cards. I think we tried to watch it, but I'm still coping with Watergate, that seminal event from my childhood, and reading books about it still. And so I think the message is that the ways of power are dark and disturbing, and the goal of a democratic republic is to bring transparency and sunshine to as much as we can, and hope that the rule of law will eliminate the truly venal from political life. As we see each day in the papers, it's an ongoing struggle, and maybe that's the way it is. We'll never arrive at perfection in politics. It's all about process. It's all about rule of law. It's all about integrity, and it's all about communities of like-minded people insisting that their public officials adhere to common standards of decency. That's why we come to you each day, because we're trying to foster that discussion. Have a great weekend, everyone.
Yeah, absolutely. If you're on LinkedIn, I think there's a hashtag. I think there's someone that follows us and is connected with me on LinkedIn, Norm. I don't want to say his name out loud because I think he likes to kind of stay low key, but he mentioned us in a comment on LinkedIn. It's like Dear1L, hashtag Dear1L on LinkedIn. I think there's a series of letters that people are writing. If you're on LinkedIn, just pump Law and Legitimacy on that hashtag. And I don't know if it's active on Twitter. I haven't done any research, but outside of that, please follow us on X/Twitter. At LawPod Daily. We're just about 100 followers away from being able to unlock that subscriber feature and begin to do a little more creative stuff there on that platform. And that's after, we've done a recent push and we've gotten like another couple hundred followers in the last month, which is awesome. So thank you. Keep sharing us. And aside from that, you can find us here every Monday, Tuesday, Wednesday, Thursday, Friday, 8 a.m. Eastern on Rumble Video, YouTube Live, and of course on X Live. And if you don't catch us live, you can find us on Apple Podcasts, Spotify, Google Play, Audible, etc. Consider giving us 5 stars and a nice comment. Norm, have a great weekend. You're almost in vacation mode. You're almost vacation, Norm. I think I see you sort of like coming out of the cocoon, about to spread your wings. I
was there yesterday. We got a lot of information in several cases that I had to spend the evening dealing with. So I tossed and turned all night, but I'll do my best this weekend to get back to it.
Well, we'll see you on Monday. And I think the last comment we got was from Justin Carta. No weekend. Have a great weekend. No weekend show. We got to keep you on your toes. Maybe.
Yeah, Justin. Yeah.
Maybe. Anyway, Norm.
We'll get us Vivek, and we'll do them anytime.
That's right. That's right. Go tweet at Vivek. Tell him to come on. All right, Norm. I'm going to let you go. I'll talk to you Monday.
Great weekend.
Thank you, everyone.